Well, there's been a lot of change in divorce and financial related matters in recent times. Gone is the need to outline unreasonable behaviour and allegations of adultery as part of issuing a divorce petition. No fault divorces are here and they're here to stay. This does seem to be the right way forward, not least in situations where parties are living under the same roof due to financial restrictions pending an overall resolution of matters. And ultimately, if a divorce petition is issued and you have to quote unreasonable behaviour or allegations of adultery, this can only increase the tension in the household whilst parties are living together pending a resolution of matters. Also, it's right to say that in financial matters on divorce, it's rarely the case that allegations of behaviour can influence judges one way or the other, so the no-fault route would seem to be long overdue. All that there needs to be now is at least one of the parties to maintain that the marriage has broken down irretrievably and make a declaration to that effect, and ultimately the other party is not in a position to defend that. Despite the no-fault philosophy, there's still a need for a respondent to reply to a divorce petition, and an evasive respondent can delay the process. But there's the key word: delay. Not defend, not cross-petition, not totally frustrate the progression of matters. Delay only, and delay that ultimately will be overcome. However, even a cooperative respondent, although welcome, is not the end of the story. Once a divorce petition is issued, there is a 20-week time lag before anyone can apply for a conditional order, what used to be called decree nisi, and there's a further time scale before the decree nisi or conditional order can be made absolute. I generally describe it as two trains that run down two tracks at the same time. End my marriage, sort out the finances. There are effectively four ways to resolve financial matters on divorce. The first is to come to an agreement with your spouse and have this written up at some stage. The second is to attend financial mediation and have a professional individual assist you come to an overall resolution of matters. The third is to negotiate matters through your respective solicitors. And the fourth and final way is, of course, to have a court involved in imposing a settlement on the two of you. Under the first two scenarios, and eventually the third if you get there, a consent order would be drafted, signed by all parties and uploaded to the family law portal for consideration by a judge and hopefully its approval on a once and for all basis. If things drag on more than 6 weeks after the granting of a conditional order, there's a decision that you and your solicitor will have to make. Do we apply for the decree absolute immediately, or do we delay this until financial matters are the subject of an overall resolution? Certainly, if your matter is going down the route of court proceedings, there will inevitably be longer than 6 weeks between the conditional order and when finances are resolved. So whether to apply or not will be a legitimate consideration for you and your solicitor to discuss. In extreme circumstances, over a year can transpire between the conditional order and when it's right to make a decree absolute application. And if this did happen, there are generally some minor level of increased formalities that need to be dealt with at that time. The process of addressing financial matters through the courts is never welcoming. They can be acrimonious, timely, and of course very expensive. But there's a balancing act here. The only advantage of court proceedings is that they do guarantee a level of finality at some stage in the future. Whereas if you're negotiating with the other side, of course this is the preferred option. but it does rely on good faith to be shown by them, both in terms of being full and frank, in terms of disclosure, but also in terms of responding in a timely fashion to requests for, say, information and documentation, and being reasonable in the negotiation process generally. So you must weigh up during a case what is the preferred way forward, and it might be that you and solicitor decide to change tack if the negotiation route simply isn't progressing matters effectively. Well, at Bird & Lovibond, we offer a fixed fee appointment, and during that fixed fee, I will go into more detail with you on the divorce process and the link between that and the financial related matters, and of course, concerns regarding children. What I will also try and do is give you something of a preliminary indication as to what sort of settlement you're looking at, given the assets in your matter and indeed the circumstances relating to you and your family.